And if I was not already blacklisted by TuneCore, I'm gonna be after today's video. As you guys know, and you've been following on this channel, we have been talking a lot about TuneCore, right? And this originated from, I'm a lawyer and one of my clients had an issue with TuneCore. Actually, a bunch of my clients have issues with TuneCore, but one in particular asked us to send a demand letter and seeking, his royalties, which were being withheld by TuneCore, and they had alleged streaming fraud, and they locked him out of his account and then not communicated with him. And so he was forced to hire us just to even get a response. And at that time, and in context of that, we had been in communication with TuneCore and we're duking it out for just months. And we looked at the terms of service, but we didn't necessarily go through the entire thing with a fine-tooth comb, which is what we're doing today. And guys, we've looked at terms of service completely all the way through for platforms like DistroKid, CD Baby, all of which you can check out on this channel. And there's some commonalities, there's some stuff we're pointing out because we care about what do these distributors do to take your money? What can they do to disenfranchise you? Which was all started because of the language that we read in the TuneCore Terms of Service. And what I can tell you, without exaggerating, is that no less than 30% of what we're going to read together through the TuneCore Terms of Service are dedicated to explaining all the ways that they're going to take your royalties, all the ways that they have the right to kick you out, take your money, and even come after you for stuff that they have paid to you. And so whereas I didn't think that my perception of TuneCore and the experience that we had, the representatives and TuneCore calling our client a scumbag and really just being you're the middleman here. You're the one that should be kind of protecting artists and working on behalf of artists and all this stuff. So setting aside that particular issue, the idea today is that we're looking at these terms and I just didn't think this could get worse. And then I actually read the terms of service completely through today. And if I was not already blacklisted by TuneCore because of what's been going on with our client and that whole situation, I'm gonna be after today's video. So with that being said, let's jump into this. As you guys know, what I like to do is that I always plug this in as far as the terms of service into a Word document. I will make this available to you because I go through and I highlight and you like to take a look at this and have a copy. So I'll make sure to provide this to you. So if you guys remember when we did our TuneCore Exposed video, we had noted last updated December 11th, 2023, and we're like, oh wow, that's really weird because our initial demand letter that went to TuneCore was dated December 1, 2023. And this doesn't mean anything necessarily, but every time there is some big dispute with a company and a company updates their terms, it's because they're reacting to some situation. That's usually what it is, okay? I work with a lot of companies, it's whatever. And so we sent our letter on the 1st, and then just so happens that they updated their terms of service on the 11th, 10 days later. All right, so in any case, guys, normal stuff. This is a legal agreement. You agree to this agreement when you click the I accept, right? And that's normal for all these distributors. You hereby agree that any modification of these terms of services shall not be interpreted to reflect upon the strength of any provision in any earlier iteration of these terms of service. So anyway, I kind of laughed when I read that because I just made this whole point. I'm like, what does that mean? It was just updated. And they're like, you agree that modifications that we make should not be interpreted to reflect upon the strength of any provision in any earlier iteration of these terms of service. I'm like, man, they're really contemplating this stuff, aren't they? Anyway, so yeah, when you say I agree, you are signing this contract. So here's all the stuff. And I just want to note what stuff they get into right away. So they go in regards to intellectual property rights and any third party. You acknowledge and agree that company may disable accounts and or terminate your account and or remove or disable access to any recordings, so any of your music, in the event that company receives any claim, if true, which would constitute a violation of your reps and warranties here under. So they go, if true. I just kind of rolled my eyes at that because part of our whole issue with TuneCore and the issue with our client was that TuneCore never actually provided evidence of this alleged streaming fraud, right? So meaning screenshots or we're talking to DSPs and the DSPs are saying these things and they just copied and pasted text, or they allegedly copied and pasted text and they didn't actually show any screenshots. They didn't show the streaming fraud. So our problem was TuneCore generally, what we figured out is that TuneCore generally has the right to forfeit the royalties for anyone on their platform. And we'll go through this in a second. And, we were like, well, even taking any of that as true or lawful, how do you know these claims are true, right? So what if someone just claims there was copyright infringement, which happened to one of our clients? They're like, your cover song is sampling. It's not actually a cover, which wasn't true. And so I had to go through the process and fight with the label and all this stuff. So if someone files a claim, we were like, TuneCore should not just be able to forfeit your royalties. But anyway, I was when I was reading this, I was well, it does say here that in the event of these claims, if it's true, so meaning someone has to claim something, I'm like, oh, that's good, that's something. So let's keep that in mind as we are continuing. You agree not to engage or permit, encourage, enlist, retain, or employ third parties to engage in activities in company sole discretion constitute streaming manipulation. Now, guys, remember I talked to you about in your contracts when they have words that have capitalized first letters. That means it's defined. When it's not defined, we don't really like that. So here they're like, here's how you define it. Streaming manipulation means any activity or method which involves artificial creation, human or non-human, online or offline, plays, audio-visual streaming services, where such plays do not represent bona fide end users listening, views initiated by genuine people, so like fake plays, right? Streaming manipulation may involve or include, but it's not limited to, increasing, generating play count, sales, follows, counts, engagement, all the things. And we talk about this and we're like, look, we're not here advocating for fake streams, okay? Because you're gonna get spanked. You just are. Like, your algorithm will get crushed. You can get sanctioned now on Spotify. It's no good. And we see, music distributors, CD Baby, DistroKid, we've reviewed their terms, and they're like, don't do it. And if you do it, we have the right to kick you off the platform, which again, we're like, we don't even have a problem with that because you could get the distributor sanctioned. So we don't necessarily have a problem with any of that. You should be aware that streaming manipulation may be the result of actions of a third party. This is a question you guys bring up. You go, well, what if I hire a marketer and they pay for fake plays? I don't even know it. Such as a promotion or marketing company, record label, music distributor acting on your behalf. You're encouraged to do your own investigation, okay? Like, it's not our fault. For the avoidance of doubt, any streaming manipulation done by a third party on your behalf that relates to your music is a violation of these terms of service, okay? Again, I don't necessarily have a problem with that, okay? Like, it sucks. You go and you drop, most people are like, just give me a quick 1,500. I'll run this campaign. I'll get you 20,000, views and all this stuff. And maybe they don't even know that paying for the fake bots to go and get you those streams is going to get your stuff taken down. And not only taken down, but in some cases, like on TuneCore, taken down and then they take your royalties. Certain consumer stores that use your music recordings may also have policies related to fraud, suspicious fraudulent activities, become aware of those policies, you're bound to them, that's fine. In the event that company has, in good faith discretion, reason to suspect is the standard here, that your account or your music has been subject to, involved in, or generated revenue from violating the terms of service, right? So these terms of service, fraud, infringement of copyright, trademark, right of publicity, or any intellectual property. So these are all the potential claims they're talking about. Failure to comply with any third-party license requirement or streaming manipulation, which is hereafter collectively defined as improper conduct. So improper conduct is all the stuff we just said. Then, company reserves the right to, 1, discontinue posting of income so they can stop paying you. 2, block your ability to otherwise withdraw the funds from your account until resolution of the suspected activities, until satisfaction of TuneCore is obtained in its own good faith discretion that such funds are not attributable to your naughty conduct. And 3, remove any and all of your music from any of the DSPs, right? Consumer stores. You further agree that any revenue currently in your account and or past earnings, which are attributable to improper conduct, will be forfeited and or returned to you, if applicable, if company determines in its good faith discretion, right? So only TuneCore gets to make the decision. If TuneCore decides that you have engaged in any of these things that qualify as improper conduct, that your account, your music, subject to, involved in, the revenue is forfeited. This goes back to our big issue on behalf of our client. We go, besides the fact that they didn't prove or show anything, and our client had tens of thousands of dollars of royalties locked in his account. And we're like, but even if that was true, and he is a big fraudster, because it became like super personal, and they were calling our client a scumbag, and they said his music sucked, and like all this stuff. I'm like, what is happening here? But I go, I'm not an advocate for fake streams and all that, but even if I go, you can't just take someone else's royalties. So they have a nice big paragraph there. And my issue with that specific paragraph, which I noted elsewhere, is that it doesn't say if proven. It doesn't say if true. It doesn't say anything in regards to other than TuneCore just making the determination. And that's really problematic for me when you have a contract that you guys are being forced to sign when you use this platform, And the majority of you will never read this, have never read this, which is why we're doing this here today. Because guys, we are not done. We're on page 3 of this. And so far, we've just been talking about the forfeiture of all your royalties. You further agree, you're going to provide company, with information that it needs when it asks. You're going to, if you get a DSP like Spotify, if you get a notification in regards to all that thing, all that stuff, you're going to give the information over to TuneCore. Upon TuneCore's determination that your account or your music have been subject to, involved in, or generated revenue from your improper conduct, alleged, you agree that all revenue in your account that has been frozen by the company is forfeited. So they say it again, right? So they just keep beating our heads against the wall and saying it over and over and over. Is forfeited, regardless of whether it was generated from any specific recordings or DSP. You agree that TuneCore's good faith determination of improper conduct can be based on streaming or other activity that is the same or similar to cases that the company has previously determined involved proper conduct. So my law office gets hired usually when there's enough money in your guys' accounts that you're like, all right, it's worth, paying a lawyer to send a demand letter. I'm not getting a response from these companies. And so we jump in. And this was the first time that we were dealing with a distributor who just put up a brick wall right out the gate. Because normally it's we'll have some conversations, we might get the account reinstated, we might get music reinstated, we get royalties released and all this stuff. Because usually our position is, hey, glorified bank, which is what you are as a music distributor. You are a bank. Artists and producers are forced to go through you, and you distribute the music and make the money because you can't get your music on music platforms otherwise. And I go, you can kick people off your platform all you want. I'm not going to say anything about that because that's your contract. Cool. But when it comes to you converting, meaning under the law, taking someone else's thing, when this thing is the royalties, I don't think so. And so we send a big scary letter and we normally get positive outcomes for the clients. And so this was the first time, right out the gate. I mean, TuneCore was just not having any of it. And to a degree, I understand why now, right? I understand why because I, was rolling in the mud with them for the last 4 or 5 months. But I also stand because, reading the terms now, again, more thoroughly, this is how they do their business. Anyway, let's go back because we are certainly not even close to being done. Company has no duty to investigate improper conduct unless and until it freezes revenues in your account. Okay, so they're just because stuff happens. Maybe they haven't frozen your royalties yet. They kick you out and they block you and they take down your song, but they're not going to look into anything until they're all right, we're freezing your money. If company determines that revenues generated to your account are the result of improper conduct and such revenues have already been paid to you. So have already been paid to you. You agree to return such revenues. So you agree to give your royalties back to TuneCore, and TuneCore may, in its sole discretion, deduct such amounts from the current balance in your account or from any future revenue that would otherwise be payable to you. So they're like, hey, we think you engaged in streaming fraud. And, again, maybe you didn't do anything, right? So maybe there really is no claim here, or maybe something happened, right? Maybe a marketing company paid for something, got you into trouble, who knows? And they're like, that $5,000 you made over the last 5 years with us, gotta pay it all back to us. That's what the contract says. Company shall have the right to retain and or redistribute to third parties any funds or the monetary equivalent thereof, which TuneCore determines in good faith discretion are attributable to improper conduct. I threw a fit in regards to that line right there. TuneCore shall have the right to retain not just your money, but to redistribute, to give it to third parties. So that means literally anyone. They can send your royalties to anyone for any reason. Once they're like, there's an allegations of improper conduct here, boom, the hammer comes down. So, for purposes of our client, we just hit the roof with that. All right, you agree. You will not be entitled to reimbursement of any fees paid to you by company in the event. So, you paid to use the TuneCore platform. They're like, if we disable your account, you're not getting a refund, or any other materials that you provided to company or any revenues forfeited as set forth in the preceding sentence. Just as a kind of pro tip for you guys, if you're ever leaving a distributor, sometimes you can make a request to the distributor and you go, hey, I want copies of all of my assets that I gave to you. So this happens to some of our clients. We need to get copies of the WAV files that we uploaded. We need cover art. We need metadata. And so you usually can get that given to you back by the distributor. So just keep that in mind before you just terminate and leave, because you might be able to get it kind of like nicely packaged if you haven't done this already for yourself. So little pro tip there. All right, so you agree basically we're not going to reimburse you your fee. So to the extent that company, that TuneCore in its good faith discretion, do you guys see how much they have like in its good faith discretion, determines that any improper conduct was caused by you or your affiliates, right? So we go back to the example of like a marketer, right? A marketing company, or your affiliates' actions or omissions, or by any third party acting on your behalf or at your direction. Any cost incurred by company, including legal fees in connection therewith, may, in addition to other remedies, be deducted from what they pay you. And this was one thing where, we saw this in DistroKid's Terms of Service. I think we saw it in CD Baby's Terms of Service, and that's okay. This is one thing. I don't have a problem with that. When a company determines you actually did the naughty thing, and then they have to hire an attorney for whatever reason, or they have to pay a sanction, or just there's some way that we can look at a real damage that a company incurred because of your bad act, I don't have a problem with a company saying we get to reimburse ourselves for those real damages. My problem out the gate with TuneCore was we had a client who had tens of thousands of dollars of royalties, TuneCore saying you forfeited those royalties because you did these bad things, and TuneCore wouldn't provide evidence saying that in fact those bad things happened. But then, we went even further on this because, as we will see as we continue to go through this, these terms of service, this contract is subject to New York law, right? So in the contract, it goes, this is going to be interpreted by New York law, and if we have to lawsuit, it's in New York, blah, blah, blah. And so we did that research and we're like, okay, according to New York law, what does it say? And we found that pursuant to New York law, you can't have impermissible penalties, which is what this is, right? So they go, if you violate our terms, even if we don't have any kind of damage, our penalty to you is that we're just going to take all your royalties. And we go, TuneCore, PS, like that's what the law says. So even though it's in your contract, you're like, it's in our contract. He said, he signed it. Like, I don't care if that is, in your contract. Not okay, pursuant to the laws that apply to this contract. All of which TuneCore ignored. Ever dream of getting your music into TV, film, and games? Well, it's easier than you think. And here's what I put together for you. A music library database of 90 plus music libraries, email templates, and a license agreement, all so it's done for you. Go to topmusicattorney.com for sync licensing made easy. And guys, PS, the blue is really hot. In the event that any consumer store, so meaning a music platform, charges you and or company a monetary fee or a penalty as a result of improper conduct, so right, you get sanctioned in connection, you agree that, we can deduct those from your royalties, we get to reimburse our fees. I don't have a problem with any of this. Okay, and or charge any alternate payment method you provide to the company, such as PayPal, credit card, debit card, each a payment method. Okay, so there's a difference here. And I have not seen this in any terms of service that we have reviewed for any of these music platforms yet, which is that for them to go and be like, we incurred $5,000 of legal fees, blah, 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 blah. Instead of just taking it from your royalties, they go, well, we have your credit card on file. We have your debit card on file. We have your PayPal account on file. We reserve the right, and you already agreed by signing this contract that they can just go and charge your card. So I have a problem with that. If in company's reasonable business judgment, it elects to engage an attorney to review potential improper conduct, respond to any third-party allegations. So they were responding to me. Top music attorney sent big demand letters, and they hired someone. Okay, and they had to pay that person. So this is the kind of thing that they're talking about. You agree to pay those costs with a minimum of $300. Again, this is all within that realm of like, generally speaking, I don't mind if there's a legitimate claim, everyone's providing evidence that they have, yada, yada. In our case, which TuneCore didn't. You agree that company reserves the right and may terminate your account in its sole discretion for any reason, anytime, including if in TuneCore's good faith discretion. We need to every time that comes up, we need to count how many times we see this. In their good faith discretion, you are believed to have engaged in improper conduct. So again, it's something just keep repeating over and over and over and over. The forfeiture of royalties, TuneCore gets to make the final decision on all the things. And just for reference, guys, right now we're on page 4 of 13. So literally all of this, the first 30% of these terms was dedicated to explaining to you all the ways that they can take your royalties, kick you out, you can't do anything about it. Oh, and by the way, they can charge your card as well. All right, so let's move on because it gets better. So now we're going to go into section 3, and section 3 talks about payments, right? And I'm like, oh, okay. So like, this is how you get paid. This is whatever. And then as I continue to read this, I'm just like, what? So section 3, company will pay you 100% of net income. Okay, cool. So, that's just all the money that you make, less obviously like store fees and things like that. And then down here, it just goes any lawsuit arising therefrom, so meaning, and let me clarify. So any objection related to accounting statements that TuneCore gives to you, you have a statute of limitations. We talked about this for the other distributors as well. They do the same thing, which is they generate a statement and they give it to you. And then they say there's a certain period of time that you can object to this. And if you don't, then you waive the right forever and ever and ever. So in TuneCore's Terms of Service, I'm just pointing this out. It is kind of industry standard. Pretty much everyone does this, okay? It's to protect and insulate the company. So 10 years later, you can't come back and bring a claim or whatever. But they have a 1-year statute of limitations on this. So just keep that in mind, okay? And actually look at your statements and bring a claim if you see something. To the extent that you owe any amounts to company as a consequence of the Terms of Service or otherwise, company shall have the right to deduct all the portion of such amounts from any net income otherwise payable to you. So yet again, being like, hey, we have the right to, take from your royalties. The net income posted to your TuneCore account will be pooled. Guys, I got to this part right here, and this thing, I just have never seen it for a music distributor, and it's so infuriating to me as an artist myself. Let me just finish this. So the money that is posted into your TuneCore account, your royalties, will be pooled, put together in an interest-bearing bank account. Okay, so they put it in an account. I was like, this is, as the money just sits there, it'll make like 5% a year, like whatever it is. So it's going to make money on your money with the net income of other TuneCore customers. So all your guys' monies, they're all together until you withdraw your funds. You agree that you will not receive interest on other earnings on the net income that the company, so that TuneCore handles as your agent and places in such pool. In our whole conversation about how, as a business practice, TuneCore is taking considerable measures in its contract to make sure that it can kick you out, it can take your royalties for so many reasons, and that you contractually did sign something to try to prevent you from coming back and arguing about it or whatever. But they also are so business savvy that they're going to make sure that your money as it sits in these accounts is going to make interest. So you are literally making money for TuneCore in a whole different way than even what's contemplated with these distributors, which sometimes you distribute your music and the distributor might take a little percentage, right? And so they kind of make money that way, or you pay them for extra, services. You pay to use their platform. This is the first time that I'm seeing one of these distributors going and, if this was my money, you're going and making money off of my money. Like, this just feels so not good. In consideration of your use of the services, you irrevocably transfer and assign to company any ownership rights that you have in any of that interest. We get it. You don't. Section 5, warranties, reps. All right, so lots of things, that we see in a lot of these other terms of service, right? So you have to be at least 18 years of age. And I just kind of wondered about that because there's so many of you who are like new musicians and you're not 18. I'm like, I wonder what they're doing with that. If you're like 15, 16, distributing on their platform. Anyway, just know that you are supposed to be at least 18 years of age. Section 6, talking about subscription fees. In consideration of the services rendered hereunder, all recordings submitted by you and distributed by TuneCore to the music platforms require that you purchase a reoccurring fee-based subscription. Okay, so they go, you're paying to have our stuff. Such fees cover TuneCore's admin expenses, for their artist support, ongoing manual maintenance, all our stuff. And they go, these fees may be amended from time to time by company without notice to you. At this point, I'm just pointing out stuff where I'm like, okay, we get it. If we're on these platforms, sometimes platforms change and they increase their fees, not sometimes. They always increase their fees. But I'm like, TuneCore goes so far where they're like so intended on protecting themselves in every kind of way, and making sure that there's no way that you can come back. They're going to take your royalties. They can give it to third parties. You can't say anything. And they're like, we're going to amend the fees from time to time without notice to you. As general business practices for a company, you can't send an email, be like, hey, it cost you $40. Now it's going to cost you $70. Now I'm going to let me know. Section 8, confidentiality. Okay, so they go in, they're like, you can't talk about all the proprietary things you learn. If you learn anything about us, you hereby expressly agree that company shall have the right to provide information relative to the sales of your recordings, your music, to third parties. Who's that? I'd love to know. Who are you giving my information to aggregate such information in chart and other comparative informational materials and to disseminate the same in any manner. Gotta be honest. I don't like that. Oh, look at that blue. Every time you guys see blue, it's because I just like threw my hands up when I got there. Let's see what this one was. Section 10, barcodes and universal product codes. Company will provide you with free barcodes and universal product codes, which are UPCs. All right, so if you guys remember, we talk about this, about your ISRC numbers in particular. Not every distributor gives you both ISRC, which is a code attached to each of your songs. And the reason we really want to pay attention to that and make notes of it, right, put it in a Word document, is because if you ever change distributors, re-upload the music, when you upload it, you go, hey, here's my ISRC numbers for these songs. And then when it's redistributed, all of your songs have the original plays on them. Great. So that's the little trick to do that. So not all distributors give you both the ISRC as well as a UPC. But what they say here is they go, we give you this stuff for free, which every distributor does, right? They just assign you one if you need it. But these are for your use only and may not be transferred or resold. If transferred and resold, company TuneCore will charge you $25 per barcode or UPC, plus any revenue made by you from such transfer or resale. So the two problems that I have with that is that, for example, I do these big music catalog purchases and sales. Like last year, we sold $9 million of music catalog. And with that, we go, hey, here's all the music. We do big Excel sheets with metadata and has all of the, those barcodes, as the ISRC numbers and all that stuff. So what they're saying is that if we went and we're like, oh, wait, some of this music was distributed on TuneCore, we have to go back and it goes, we'll charge you $25 per barcode, which is just, no one does this. They go, you have to pay us again. And then they go, plus any revenue made by you from such transfer or resale. Like the magnitude of that and how that could be used. Like, are you telling me that the money made from me, my $9 million that my artist made, that I'm supposed to give that to you? I don't think that's the intention. I think that maybe there was some like poor wording here or something, but like, what the F? Even as to just the $25 per, thing that you allegedly got for free. They're like, you get it for free from us. Well, it's not free. It's apparently on a license. All right, so I'm going over this. I meant to review this. They have a separate agreement and I wasn't sure, so maybe you guys can tell me. So they have separate terms for artificial intelligence and machine learning. And I was like, this kind of sounds like you're opting in for the AI learning. I didn't have a chance to actually review these terms. I wanted to, but I just wanted to make sure that for those of you who are using TuneCore, that this is in fact something that you can clearly opt into and it doesn't just automatically happen, which was my concern when I first saw this. So we may need to come back and take a look at that. But moving on, we're coming up on it. So section 13 here, you and TuneCore agree that the company may bring claims against each other only in your or its individual capacity and not as a plaintiff or class member in any purported class or representative proceeding. Well, there's our answer. So for the matter pertaining to our client through our law office, we had talked about this and we go, look, right now our client is the one that has these claims. Our client would be the one that sued, right? So we drafted a complaint to be filed in New York in accordance with their terms. And we spoke with you guys because there were just so many of you that came out just saying, wow, these problems that you're talking about, I've had these, they took my royalties, what do I do? And just wanting to join and to become a class. So what TuneCore has done, pursuant to what we just read, is that they have ensured that actually you cannot do that. You cannot do that because it says you will not join as a class member in any purported class or representative proceeding. So there you go. You just signed away your rights. All right, moving on. We are in miscellaneous now in section 14. Okay, so C, company shall not be deemed in breach of the terms of service unless you give the company notice. Okay, so this is something we've read in the other terms. You have to usually send an email or send a letter or do something. And if you don't, then you have not given them notice. And so there has not been a commencement of a claim of breach of contract. I want to point that out because, as always, guys, I'm gonna give you exactly what you need as far as who you need to contact, what you need to do if you have a claim against any of these companies. So number one, you have to give them notice, at least 30 days. This I just want to mention briefly. So it's normal in contracts where they have something called the force majeure events. And so basically in contracts, they go, hey, if there's an act of God, so that's what they call it. If there's some, a new COVID and everything gets shut down and business stops, or there's like an earthquake and all of our employees are swallowed up, you know what I'm saying? Like some crazy thing happens. Typically in these contracts, it goes, we are like the contract stops. We can just take a pause to deal with the thing. And then when the thing ends, we move on, the contract starts again. So that's normal. What's not normal is the tail end of this. They basically go like in the event that there's one of these force majeure events, and it prevents us from, basically paying you your money. We'll be excused from paying it for the time that the thing is going on. Okay, don't have a problem with that. And any net income payment shall be paid after the conclusion of the force majeure event, notwithstanding the foregoing. In the event that the company anticipates that a force majeure event will prevent the payment to you of your royalties indefinitely, or that a force majeure event may permanently prevent you from receiving or withdrawing net income, company shall use its best efforts to get in contact with you. But basically it says that the same thing can happen, and they can just basically forfeit the amounts. So this certainly is not as inflammatory as some of the earlier language, but it's yet another way that they're like, hey, just so you know, there's a way that maybe you'll never get your royalties. Oh, here we go again in blue. I don't know why I made blue the bad color. I should have made it red. I don't know. I was just highlighting this as I went. In no event will company, its officers, directors, employees, or agents be liable to you for any damages whatsoever, including without limitation, indirect, incidental, special, punitive, or consequential damages. Now you're like, what the hell does that mean? So it means that when we file a lawsuit, we go, for example, our client, we're like, let's pretend the number was, just saying, $60,000. And we go, you, TuneCore, took $60,000. And so we're suing you. Those are our actual damages. And so what they just, gave you the list of, they're like indirect, special, punitive. These are extra things that you can get by way of the law. And if you're like, I had to hire Crystal, and Crystal charges a lot of money. We want to get Crystal's attorney's fees reimbursed. Attorney's fees are considered consequential damages, meaning you wouldn't have had to hire me and pay the lots of fees and all the stuff if TuneCore didn't breach the contract or do these bad things. So what they're doing is they are getting you to waive your right to seek these additional damages through this language. And you just did, because you signed this thing, right? But we're not done. So the punies, consequentials, you're waiving all that stuff. And this is in regards to companies' websites, services, products, content. No matter whether the damages are foreseeable or whether or not the company has been advised of the possibility of such damages. So even if it was super malicious, even if they didn't, they did something with the intent to cause you harm, you still cannot sue for these things. And this is my very, very favorite. The foregoing limitation of liability will apply to the fullest extent permitted by law in the applicable jurisdiction, and in no event will TuneCore's aggregate liability exceed $100. So that's it. That's it. They're saying that if you sue, you can get no more than $100 from TuneCore. When attorneys draft these things, part of it might just be like, well, of course, we're setting them up for success and we're really protecting TuneCore and all this stuff. But I'm like, dude, this whole thing taken collectively. So the following stuff I already mentioned: New York, we have to go to New York if we're going to sue, the courts in New York, lawyers in New York, everything in New York. And then for the contact information, I really wanted to point this out. So any notice, if you need to send, make this big so you can really see, any notice that you need to send in regards to breach of contract or whatever, you have to send it to TuneCore by email. The email is copyright@tunecore.com. So if you have a problem right now and you have a legal claim, you want to give them notice in writing and send it to copyright@tunecore.com. So going through this and understanding that it probably was a lot more than 30%, but when a company dedicates so much time and thought to making sure that they have the right to take your royalties just for claims that might be brought against you, not that anything was proven, not that anything was actually true, that's really shocking to me. And now having compared music distributor terms of service between some of the biggest ones and been like, yeah, there's some stuff we don't like, here, there, I was shocked going through these terms of service and quite frankly disgusted. And that's kind of what I've been saying from my experience representing this particular client, other issues that we are working on right now with TuneCore. But going through these as detailed as we did today, it's hard to even have words. Guys, I would really love your thoughts. Are you currently using TuneCore? Drop a comment down below. How's your experience been? Are you using a different platform? Understanding this contract that you are signing with this platform is really important. So I hope you found this helpful, and I'll see you on the next one.